I was standing in my kitchen on a Tuesday morning when I noticed something strange through the back window that made my coffee mug freeze halfway to my lips. There was a brand new shed sitting on the far corner of my property, except I had never authorized anyone to build it, and I certainly had not built it myself. My name is Keith Calloway, and I had lived in the Riverside Meadows development in Gilbert, Arizona for 3 years. It was one of those planned communities where every house looked vaguely similar, and the homeowners association had rules about everything from mailbox colors to how many inches your grass could grow before you received a violation notice. I had dealt with my fair share of ridiculous HOA complaints over the years, but nothing could have prepared me for what I was looking at right now. I walked outside into the warm Arizona sun, crossing my backyard toward the structure that definitely had not been there yesterday. It was a decent-sized storage shed, probably 10 by 12 feet, with gray siding that matched absolutely nothing on my property. As I got closer, I could see it was professionally built with a small ramp leading up to double doors. The whole thing sat squarely on what I knew to be my land, about 15 feet from my back fence line. I pulled out my phone and took several pictures from different angles. The shed looked brand new, with fresh wood and no weathering whatsoever. Someone had clearly just finished building it, probably within the last day or two. I walked around the perimeter, looking for any signs or markings that would explain what was happening, but there was nothing. My neighbor, Tom, was outside watering his plants. I called over to him. "Hey, Tom, did you see anyone building this shed yesterday?" He looked up, squinting against the morning sun. "Oh yeah, there was a crew here most of the day. I figured you had hired them. Nice shed." "I did not hire anyone," I said, my voice tight with confusion and growing anger. Tom's expression changed. "Seriously? Then who built it?" "That is exactly what I am about to find out." I went back inside and immediately called the HOA office. The phone rang 4 times before someone picked up. "Riverside Meadows HOA, this is Brenda speaking." "Hi, Brenda. This is Keith Calloway at 4782 Seguero Lane. I need to speak with someone about an unauthorized structure that appeared on my property." "An unauthorized structure? Did you file a complaint about a neighbor?" "No, someone built a shed on my property without my permission." "I need to know who authorized this." There was a pause. "Hold on, let me transfer you to Patricia." The line clicked and I waited, my frustration building with each passing second. Finally, someone picked up. "This is Patricia Daniels, HOA president. How can I help you?" Patricia Daniels. I had heard that name plenty of times, usually attached to violation notices about my trash, cans being visible from the street, or my holiday decorations staying up too long. She was the epitome of an overzealous HOA board member, the kind of person who seemed to derive genuine pleasure from enforcing petty rules. "Patricia, this is Keith Calloway. There is a shed on my property that I did not authorize. Do you know anything about this?" "Oh, the shed." "Yes, that was built according to HOA guidelines. It is for community storage purposes." I felt my blood pressure rising. Community storage, on my private property? Well, according to our records, that section of land is actually part of the community common area. We had a surveyor market last month. That is impossible. I have a property survey from when I bought this house. That land is definitely mine. Patricia's voice took on a condescending tone that I was sure she used frequently. "Mr. Calloway, I understand you may be confused about property lines, but the HOA has done its due diligence. The shed is on community property, and it stays. I want to see this survey you are talking about. You can request documentation through the proper channels. Submit a written request to the HOA office and we will respond within 30 business days. 30 days? You built a shed on my land and I have to wait a month to see your justification. Those are the rules, Mr. Calloway. Have a good day." She hung up before I could respond. I stood there staring at my phone, absolutely incredulous at what had just happened. The HOA had built a structure on my property, claimed it was theirs, and then told me to wait a month to see their evidence. I was not about to wait a month. I pulled out the documents from when I had purchased the house 3 years ago. Sure enough, my property survey was right there, clearly showing the boundaries of my lot. The area where the shed now sat was well within my property lines. I took photos of the survey documents, and then went back outside to take more photos of the shed's exact location relative to my fence and house. Next, I started searching for property surveyors in the Gilbert area. I needed an independent professional to verify what I already knew, that the shed was on my land, and the HOA had massively overstepped their authority. I found a company called Arizona Property Lines with good reviews and called them immediately. Arizona Property Lines. This is Marcus. Hi Marcus, I need an emergency property survey. My HOA built a structure on my land and is claiming it is community property. I need professional documentation to prove otherwise. That is quite a situation. When do you need this done? As soon as humanly possible. Today, if you can manage it. Marcus paused, presumably checking his schedule. I have a crew that can come out this afternoon around 2. The address? 4782 Seguero Lane, Gilbert. Got it. We will be there at 2. Our fee for a rush survey is $1,200. It was expensive, but I did not care. That is fine. I will see you at 2. The hours until 2 o'clock crawled by at an agonizing pace. I tried to work from home as usual since I did software development remotely, but I could not focus on code. Every few minutes I would look out the window at that shed, getting angry all over again at the audacity of the HOA. At 1:30, I noticed movement in my backyard. Patricia Daniels herself was walking across my property toward the shed, accompanied by 2 other people I did not recognize. I immediately went outside. "Excuse me, you are on my property," I called out. Patricia turned, her expression one of practiced patience. She was exactly what you would expect. A woman in her mid-50s with a blonde bob haircut and an outfit that probably cost more than my monthly mortgage payment. "Mr. Calloway, this is community property. We are just inspecting our new storage facility." "No, this is my property and you are trespassing." One of the men with her, wearing a polo shirt with the HOA logo, stepped forward. "Sir, you need to calm down." I am calm, but I am also correct. I have a surveyor coming at 2 to prove this is my land. Patricia's expression tightened. "You are wasting your money. We have already had this area surveyed. Then you will not mind when my surveyor confirms what I already know." "Do whatever you want," Patricia said dismissively, "but that shed stays exactly where it is." They walked past me, actually unlocking the shed with a key and going inside. I watched, fuming, as they examined the interior and discussed what they wanted to store there. The casual violation of my property rights was stunning. When they finally left, Patricia made a point of walking close to me. "You should read your HOA bylaws more carefully, Mr. Calloway. You will find we have the authority to use community property as we see fit. Fighting this will only cost you money." "We will see about that." At exactly 2 o'clock, a white truck with Arizona Property Lines printed on the side pulled up to my house. Marcus turned out to be a man in his 40s with sun-weathered skin and a professional demeanor. He was accompanied by a younger guy named Jason who carried most of their equipment. "You must be Keith," Marcus said, shaking my hand. "Thanks for coming on such short notice." "No problem, so walk me through what is happening." I explained the entire situation while leading them to the backyard. Marcus examined the shed, checked the existing fence lines, and pulled out my original property survey to review. "This is pretty clear-cut," he said after a few minutes. "Your original survey shows this area is definitely within your property boundaries. Let me get my equipment set up, and we will verify everything with GPS precision." Over the next 2 hours, Marcus and Jason worked methodically across my property. They used GPS equipment, measuring tools and metal detectors to locate the original property markers. I watched the whole process, fascinated by the precision of their work. "Found the corner marker," Jason called out from the back left corner of my lot. Marcus made notes and took measurements. They worked their way around the entire perimeter, locating each marker and documenting everything. When they finished, Marcus came over to where I was standing. "Okay, here is what we have got. Your property lines are exactly where your original survey indicated. That shed is sitting about 20 feet inside your property boundary. There is absolutely no question about it. Can you document that in a way I can use legally?" "Absolutely. I will have a complete survey report ready for you by tomorrow morning with GPS coordinates, photos, and a certified statement. This will hold up in any court." "Perfect. Send me the bill and I will pay it immediately." After Marcus and his crew left, I felt a sense of vindication mixed with dread about the fight I knew was coming. The HOA was not going to back down easily, especially not with someone like Patricia Daniels in charge. I spent the evening researching Arizona property law and HOA regulations. What I found was illuminating. While HOAs had broad authority over common areas and architectural standards, they absolutely could not just claim private property as their own. What the HOA had done was not just wrong, it was potentially illegal. The next morning, Marcus emailed me the complete survey report. It was thorough and professional, with detailed maps, GPS coordinates, and multiple photos showing the shed's location relative to the property markers. I immediately saved multiple copies and printed out a set for my records. I called the HOA office again. "Riverside Meadows HOA, this is Brenda." "Hi Brenda, Keith Calloway again. I need to speak with Patricia Daniels immediately." "She is in a meeting right now." "Then get her out of the meeting. This is urgent, sir. I cannot just interrupt her meeting." "Fine." "Tell her I have an independent property survey proving the shed is on my land, and if she does not call me back within 1 hour, my next call is to a lawyer." I hung up. My phone rang 15 minutes later. "Mr. Calloway, this is Patricia. I understand you are making threats now." "Not threats, Patricia. Facts. I have a certified property survey from a licensed surveyor proving that shed is on my property. The HOA needs to remove it immediately. We have our own survey saying otherwise." "Then provide it to me. Right now. Email me a copy." There was a long pause. "I will have to request that from our surveyor." "You do not have a copy readily available. You built a structure based on a survey you do not even have on hand." Our surveyor made verbal confirmation that the area was community property. I almost laughed at the absurdity. Verbal confirmation. You built a permanent structure on verbal confirmation. Patricia, you need to understand the legal situation you are in. Either you provide me with a legitimate survey showing that land is community property, or you remove that shed. Those are your only 2 options. The HOA board will discuss this at our next meeting. When is that? 2 weeks from Thursday. Absolutely not. The shed gets removed now, not in 2 weeks. Mr. Calloway, you do not get to dictate how the HOA operates. When you are violating my property rights, yes I do. You have until Friday to remove that shed, or I am filing a lawsuit. And Patricia, when I win, the HOA will be paying my legal fees along with damages. I hung up before she could respond. My hands were shaking slightly from the adrenaline. I had never been the confrontational type, but there was something about the blatant disregard for my rights that brought out a side of me I did not know existed. I decided to take the next step and called a real estate attorney. After several calls, I found one named David Martinez who specialized in property disputes and HOA issues. "Mr. Calloway, I have reviewed the survey you emailed me," David said during our consultation later that day. "This is pretty straightforward. The HOA has built a structure on your property without permission. That is trespassing and potentially criminal property damage depending on how we want to pursue it. What are my options? Several. The most direct route is to file for an injunction requiring immediate removal of the structure. Given the clear evidence, a judge would likely grant that quickly. We can also pursue damages for the violation of your property rights and any loss of property value. How long would that take? The injunction could happen within a week if we file emergency paperwork. The damages case would take longer. What about criminal charges? David paused. That is trickier. We could potentially argue for criminal trespass or property destruction charges, but district attorneys are often reluctant to get involved in civil property disputes. However, the threat of criminal charges might motivate the HOA to resolve this quickly. Let me try one more time to get them to remove it voluntarily. If they refuse, I want to file for that injunction immediately. Sounds good. I will prepare the paperwork now so we are ready to go. That evening, I decided to talk to some of my neighbors to see if the HOA had pulled similar stunts before. I walked over to Tom's house first, since he had seen the shed being built. "This is insane," Tom said after I explained everything. "I mean, I knew the HOA was strict, but building on someone's property. Have they ever done anything like this before? Overstepped their authority?" Tom thought for a moment. "Well, there was that thing with the Hendersons 2 years ago. The HOA claimed their fence was 6 inches over the property line and made them move it. Turned out the HOA was wrong, but the Hendersons had already paid to move the fence by the time they found out. Did they get reimbursed? Nope. The HOA claimed it was the Hendersons' responsibility to verify before making changes. This was a pattern then. The HOA, under Patricia's leadership, was comfortable playing fast and loose with property boundaries as long as it served their purposes. I talked to 3 other neighbors that evening. 2 of them had stories about questionable HOA actions, including one woman named Sarah, who said the HOA had threatened to fine her for a tree that was supposedly in violation of landscaping rules, even though the tree had been planted by the original developer. "Patricia Daniels runs that board like her own personal fiefdom," Sarah told me. "Most of us just pay the fines because fighting it costs more than it is worth." "Well, I am fighting this one," I said, "and I am going to win." By Thursday, I still had not heard back from Patricia about removing the shed. I called the HOA office again. "Brenda, this is Keith Calloway. Has Patricia made any decision about the shed?" I think the board is still discussing it." "That is not acceptable. I gave them until Friday." "Tomorrow, I will pass along your message. You do that." Friday morning came with no word from the HOA. At 9 o'clock, I called David Martinez. "They have not removed it and have not even responded. File the injunction." "I will get it filed today." We should have a hearing scheduled by early next week. While David worked on the legal paperwork, I decided to take matters into my own hands in a different way. I went to the local hardware store and bought a heavy-duty padlock. When I got home, I walked out to the shed and examined the doors. The HOA had installed a simple lock, but they had been stupid enough not to secure it with anything more than surface-mounted hardware. I took a screwdriver and removed their lock entirely, then installed my own padlock through a hasp I bolted securely into the door frame. If the HOA wanted to claim this was their property, they were going to have to prove it first. In the meantime, they were not accessing anything on my land. I had barely finished when my phone rang. It was a number I did not recognize. "Hello, Mr. Calloway, this is Patricia Daniels. I just received a call that you have vandalized HOA property. I secured a structure on my property. That is not vandalism. You removed our lock and installed your own. That is destruction of property. Patricia, listen very carefully. That shed is on my land. I have certified documentation proving it. You do not have permission to have any structure on my property, and you certainly do not get to lock it and keep me from accessing my own land. The HOA will fine you $100 per day for every day that lock remains. Fine me all you want. I will add it to the lawsuit. By the way, you will be receiving legal paperwork soon. I have filed for an injunction to have your shed removed. You are making a huge mistake. No, Patricia, you made the mistake when you built on my property." She hung up. I actually felt pretty good about myself. For years, I had just accepted the HOA's petty rules and annoying violations, but this was different. This was my actual property rights being violated, and I was not going to roll over. The following Tuesday, I received notice that there would be a court hearing on Thursday morning for the preliminary injunction. David called me to go over what to expect. The judge will review the evidence and likely allow both sides to present their case briefly. Given the strength of your property survey, I am confident we will get the injunction. Has the HOA provided their survey yet? Nope. They keep saying they will get it, but nothing has materialized. That is telling. My guess is they do not actually have a legitimate survey, or if they do, it contradicts their position. Thursday morning, I put on my best suit and met David at the Maricopa County Courthouse. We arrived early and sat in the hallway waiting for our case to be called. At 5 minutes before our scheduled time, Patricia Daniels arrived with a man in an expensive-looking suit who I assumed was the HOA's attorney. Patricia glared at me but did not say anything. Her lawyer, whose name I learned was Richard Stokes, was busy reviewing documents. When we entered the courtroom, Judge Margaret Reynolds was already seated. She was a woman in her 60s with sharp eyes that suggested she had little patience for nonsense. "Good morning. This is the matter of Calloway versus Riverside Meadows HOA, requesting a preliminary injunction for removal of a structure. Mr. Martinez, you are representing Mr. Calloway." "Yes, Your Honor." "And Mr. Stokes for the HOA." "Correct, Your Honor." "Mr. Martinez, present your case." David stood and laid out the situation clearly and concisely. He presented my original property survey, the new certified survey from Arizona Property Lines, and photos showing the shed's location. He explained that the HOA had built the structure without permission and was now refusing to remove it despite clear evidence it was on private property. Judge Reynolds examined the documents carefully. "Mr. Stokes, does the HOA have a survey showing this land is community property?" Richard Stokes stood. "Your Honor, the HOA relied on a verbal survey from a licensed surveyor who confirmed the area was within community boundaries." "A verbal survey? You do not have documentation. We are working to obtain the written report. How long ago was this verbal survey conducted?" Stokes glanced at Patricia, who whispered something to him. "Approximately 2 months ago, Your Honor. And in 2 months you have not obtained a written report, but you went ahead and built a permanent structure anyway." The HOA believed in good faith that the land was community property based on the surveyor's verbal confirmation. Judge Reynolds did not look impressed. "Mr. Martinez, Your surveys are certified and documented. Yes, Your Honor. Both surveys, the original from 3 years ago and the new independent survey, are from licensed professionals and include GPS coordinates, property markers, and certified statements. And both show the structure is on Mr. Calloway's property. Correct, Your Honor. By approximately 20 feet. Judge Reynolds looked at the HOA attorney. Mr. Stokes, absent any documented evidence to the contrary, I am inclined to grant the injunction. Does the HOA have any other evidence to present? Your Honor, we request additional time to obtain our survey documentation. How much time? 30 days would allow us to fully investigate. 30 days while a structure sits on Mr. Calloway's property without his permission? I do not think so. Judge Reynolds made some notes. Here is my ruling. The HOA has 72 hours to provide certified documentation showing that property is within community boundaries. If such documentation is not provided, the HOA will have 1 week to remove the structure completely and restore the property to its original condition. If the HOA fails to comply, Mr. Calloway is authorized to have the structure removed at the HOA's expense. Your Honor, 1 week is not sufficient time to mobilize a removal crew, Stokes protested. You managed to build it quickly enough. I am sure removal can be similarly expedited. 72 hours for documentation, 1 week for removal if documentation is not provided. This is not a complicated issue, Mr. Stokes. The structure is either on community property or it is not. The evidence currently before me overwhelmingly suggests it is not. Judge Reynolds banged her gavel. Preliminary injunction granted. Next case. I walked out of the courtroom feeling victorious. David was smiling too. That went about as well as possible, he said. The judge clearly saw through their nonsense. What are the chances they actually have a survey showing the land is theirs? Essentially zero. If they had one, they would have presented it today. My guess is they never actually had the area surveyed and just assumed they could claim it. What happens if they do not remove it after the deadline? Then we go back to court and the judge will authorize you to have it removed. The HOA will be responsible for all costs, plus they will likely face additional penalties for contempt. Over the next 3 days, I heard nothing from the HOA. No survey was provided, no calls were made, no emails were sent. The 72-hour deadline came and went with complete silence. On Monday morning, David filed paperwork with the court confirming the HOA had not provided any documentation. That afternoon, I received a violation notice from the HOA in my mailbox. The notice stated that I was in violation of HOA rules for installing an unauthorized lock on community property, and that I was being fined $100 per day starting from the date I had changed the lock. According to their math, I now owed $1,200. I scanned the notice and emailed it to David with a note that simply said, "Are they serious?" David called me 20 minutes later laughing. They are doubling down. This is actually helpful for us because it shows a pattern of harassment and refusal to acknowledge the court order. Can they legally fine me for locking a structure on your own property? Absolutely not. In fact, this strengthens our case for damages. They are now harassing you even after a judge has ruled in your favor. The week deadline for removal came on the following Monday. I stayed home from work that day, watching out the window to see if any removal crew would show up. Morning turned to afternoon, and then afternoon turned to evening. No one came. Tuesday morning, David and I went back to court for an enforcement hearing. This time, Patricia looked nervous. Judge Reynolds did not look happy. "Mr. Stokes, your client was ordered to remove the structure by yesterday. Why is it still there?" "Your Honor, The HOA board is discussing the logistics of removal. Discussing. They had a week. The structure was built in less time than that. Judge Reynolds looked at her paperwork. I am also seeing that the HOA has issued fines to Mr. Calloway related to this same structure. Is that correct? Stokes shifted uncomfortably. The fines were issued through the standard violation process. For locking a structure on his own property that your client built without permission. Mr. Stokes, help me understand the logic here. The HOA maintains that the property is within community boundaries. Based on what evidence? You provided nothing within the 72-hour window. You have provided nothing today. Do you have any evidence at all? Stokes whispered with Patricia for a moment. Your Honor, we are still attempting to locate our surveyor's documentation. Still attempting. After months. How convenient. Judge Reynolds wrote something down. Here is what is going to happen. The HOA has 48 hours to remove that structure completely. If it is not removed, Mr. Calloway is authorized to hire a removal crew, and the HOA will be billed for all costs. Additionally, the HOA is ordered to cease all fines and violations against Mr. Calloway related to this matter. Any fines already issued are voided. Do you understand, Mr. Stokes? Yes, Your Honor. Furthermore, I am ordering the HOA to pay Mr. Calloway's legal fees to date. Mr. Martinez, submit your billing. Yes, Your Honor. 48 hours, Mr. Stokes. If I see this case in my courtroom again because your client has not complied, I will hold the HOA board members personally in contempt. That means Miss Daniels and any other board members could face jail time. Am I making myself clear? Patricia's face had gone pale. Yes, Your Honor. Good. Dismissed. Walking out of the courtroom, I felt incredible. The judge had not just ruled in my favor, she had made it clear she was done with the HOA's games. She mentioned contempt and jail time, I said to David. Was she serious? Absolutely. Judges do not make those threats lightly. If the HOA does not comply now, Patricia and the other board members could actually be arrested. That afternoon, I received a call from a number I did not recognize. Hello, Mr. Calloway, this is Richard Stokes. I wanted to inform you that the HOA will be removing the structure tomorrow morning. Finally. I also wanted to apologize for how this situation has been handled. I have advised my client that their actions were inappropriate and legally indefensible. I appreciate that. Will the property be fully restored? Yes. The removal crew will take out the structure and fill in any holes or damage to return the area to its original condition. Good. There is one other matter. The HOA would like to avoid further legal action. Would you be amenable to a settlement? What kind of settlement? The HOA is prepared to pay your legal fees as ordered by the judge, plus an additional $5,000 for your time and trouble, in exchange for you agreeing not to pursue any further claims. I thought about it. $5,000 plus legal fees would be around $8,000 total. It was not nothing, but part of me wanted to make them pay more for what they had put me through. I will think about it and discuss with my attorney. Please let me know by tomorrow evening. After he hung up, I immediately called David. They offered $5,000 plus legal fees to settle. What do you think? Well, if we pursue a full damages case, you could potentially get more, but it would take months and there is always some uncertainty with litigation. The settlement offer is not bad for a relatively quick resolution. What about the principle of it? They built on my property, harassed me, issued bogus fines, and generally acted like they were above the law. I completely understand that frustration. But from a practical standpoint, the settlement gets you compensated fairly quickly, and you avoid months of continued litigation. It is really about what you want out of this. Money and closure, or the satisfaction of dragging them through a longer court battle? I thought about it for several hours. Finally, I decided that I wanted this over with. The HOA was going to remove the shed, pay my legal fees, and give me $5,000. Patricia Daniels and her board had been humiliated in court multiple times and faced the threat of contempt charges. That felt like enough of a victory. "Let's take the settlement," I told David. "I will draw up the agreement." Wednesday morning at 8 o'clock, a removal crew arrived in 2 large trucks. I watched from my deck as they spent the next 4 hours carefully dismantling the shed, loading every piece onto their trucks, and then filling in the concrete foundation they had poured. By early afternoon, the area looked almost exactly as it had before, just some disturbed dirt that would need to be reseeded with grass. The crew foreman came to my door when they finished. "All done, sir. We will have topsoil and grass seed delivered tomorrow to finish the restoration." "Thank you." As I watched the trucks drive away, I felt a sense of relief wash over me. The physical reminder of the HOA's violation was gone from my property. The next day, David called to say the settlement agreement was ready. I drove to his office to sign the paperwork. The HOA would pay his legal fees of $2,800 directly to him, and they would send me a check for $5,000 within 10 business days. "Congratulations," David said as we shook hands. "You stood up for your rights and won. Thanks for your help. I could not have done this without you." The check arrived exactly 10 days later. I deposited it and then did something petty but satisfying. I printed out photos of the shed removal, the judge's orders, and the settlement check, and I made copies for several of my neighbors who had complained about HOA overreach over the years. Tom laughed when I showed him. "This is amazing. Patricia must be losing her mind." "I hope so. Maybe this will make the board think twice before pulling something like this again." But I was wrong about that. 2 weeks after the settlement, I received another HOA violation notice in the mail. This one claimed my front yard landscaping was not up to community standards because I had some weeds visible in my flower beds. I looked at my front yard. There were maybe 3 small weeds in one corner that I had not noticed. It was the kind of minor thing that normally would get a warning, not a violation. I took pictures of the yard, pulled the weeds, and then called David. "They are retaliating. This is clearly harassment. Save everything. Document every interaction. If they continue this pattern, we can go back to court for a restraining order against the HOA." Over the next month, I received 4 more violation notices. One for my garage door being open during the day while I was working in the garage. One for a package that sat on my porch for 6 hours before I got home from an errand. One for my car being parked in my driveway instead of my garage overnight. And one claiming my house numbers were not properly visible, even though they had not changed in 3 years. Every single violation was petty, technical, and clearly retaliation. I documented everything and sent it all to David. "This is a pattern of harassment," David confirmed. "Let me send a letter to the HOA warning them that continued retaliation will result in legal action." David sent a strongly worded letter to the HOA board and their attorney, pointing out the obvious retaliation and noting that such behavior could result in additional lawsuits, sanctions, and even personal liability for board members. The violation notices stopped immediately. I thought that would be the end of it, but the universe had other plans. 2 months later, I was having coffee with Tom when he mentioned something interesting. "Did you hear about the special HOA meeting they are having?" "No. What meeting?" "Apparently there is an emergency board meeting tonight. Some of the homeowners are trying to remove Patricia from the board." "Really?" "Yeah. After what happened with you, a bunch of people started looking into other questionable decisions the board has made. Turns out Patricia has been playing fast and loose with the rules for years. That evening, I decided to attend the HOA meeting. It was held at the community clubhouse, and the room was packed with at least 50 homeowners. Patricia sat at the front table with 3 other board members, looking defensive. A man named Greg Morrison stood up to speak. "I have been reviewing the HOA finances for the past 3 years. There are some serious discrepancies I need explained." Patricia's face tightened. "The finances are audited annually." "By whom?" "I contacted the accounting firm listed in the annual reports, and they said they have not done work for this HOA in 5 years. The room erupted in conversation. Patricia tried to speak over the noise. "That must be a mistake." "It is not a mistake. I have written confirmation from the firm. So who has been auditing our finances?" Another homeowner, a woman named Jennifer, stood up. "I want to know why the HOA paid $30,000 to Patricia's brother's landscaping company last year when we were quoted $15,000 from 3 other companies." Patricia stood up abruptly. "This meeting is out of order. We are not discussing these matters tonight." "Yes, we are," Greg said firmly. "You work for us, Patricia. We elected you to this board and we have the right to remove you. I am calling for an immediate vote of no confidence." The room erupted again. After 20 minutes of chaos, the vote was held. Of the homeowners present, 42 voted to remove Patricia from the board. Only 8 voted to keep her. Patricia gathered her things, her face red with anger and embarrassment. "This is ridiculous. You people have no idea what it takes to run this community. We know it does not take building sheds on private property and falsifying audit reports," someone called out. Patricia stormed out of the meeting. The remaining board members looked shell-shocked. Greg took control of the meeting. "We need to elect an interim president and then conduct a full audit of the HOA's finances and operations. I nominate Sarah Greenfield as interim president." Sarah, the neighbor I had talked to months ago about Patricia's overreach, accepted the nomination. The vote was unanimous. Over the next several weeks, the new board conducted a thorough review of the HOA's operations. What they found was disturbing. Patricia had been funneling HOA contracts to companies owned by her family members at inflated prices. The audits had been faked. Violation fines had been collected but not always properly deposited into HOA accounts. And there was evidence that Patricia had used HOA funds to pay for personal expenses. Sarah called me one afternoon. "Keith, I wanted to let you know that we have discovered some serious financial irregularities. The new board is filing a police report and considering pressing charges against Patricia." "How bad is it?" "We think she embezzled somewhere between $50,000 and $70,000 over 3 years. "Holy hell." "Yeah, the district attorney's office is reviewing everything now. There may be criminal charges." I felt a strange mix of vindication and shock. The shed incident had just been the tip of the iceberg. Patricia had been running the HOA like her personal bank account. 3 weeks later, Patricia Daniels was arrested on charges of embezzlement, fraud, and theft. The news made the local Gilbert newspaper, and the story spread quickly through the community. It turned out that building a shed on my property without permission was one of the least problematic things she had done. The criminal case moved slowly through the system. I was not directly involved, but I followed the news coverage. Patricia initially tried to fight the charges, claiming everything was a misunderstanding, but the evidence was overwhelming. Financial records, bank statements, invoices from her family members' companies, and testimony from other HOA board members all painted a clear picture of systematic fraud. 8 months after her arrest, Patricia took a plea deal. She pleaded guilty to embezzlement and was sentenced to 18 months in prison and ordered to pay full restitution to the HOA, which amounted to $63,000. I attended the sentencing hearing out of curiosity. Patricia looked nothing like the confident, condescending woman who had told me the shed was on community property and there was nothing I could do about it. She looked defeated and small as the judge handed down the sentence. After the hearing, Sarah caught up with me in the hallway. "Thanks for standing up to her when you did. If you had just let the shed thing go, we might never have started looking into her other activities. I just wanted a shed off my lawn. I had no idea it would lead to all this." Sometimes one person standing up to a bully is all it takes to bring the whole house of cards down. The new HOA board was a dramatic improvement. They implemented transparent financial reporting, hired an independent management company to handle day-to-day operations, and significantly reduced the nitpicky violation enforcement that had made the neighborhood feel oppressive. Violation notices were now reserved for actual problems, not 3 weeds in a flower bed. My life returned to normal. The area where the shed had been was now covered in healthy grass, and you would never know anything had been there. I went back to my routine of working from home, having beers with Tom on weekends, and generally enjoying my house without constant harassment from the HOA. One Saturday afternoon, about a year after the whole incident started, I was grilling in the backyard when Tom came over. "Hey man, I just realized I never properly thanked you for what you did with the HOA situation. Seriously, life in this neighborhood is so much better now. I was just protecting my property. I did not set out to reform the HOA." "Yeah, but you did not back down when Patricia tried to bully you." "A lot of people would have just accepted it or been too afraid of retaliation to fight. I guess I just reached my limit. Everyone has a line, and building on my property crossed it." We stood there for a moment, looking at the spot where the shed had been. It seemed impossible that such a ridiculous situation had spiraled into embezzlement charges and jail time for an HOA president, but that was the reality. "You know what the craziest part is?" Tom said. "If she had just admitted the mistake and removed the shed right away, none of this would have happened. The financial investigation only started because people began questioning her judgment after she refused to back down on something so obviously wrong." He was right. Patricia's ego and refusal to admit error had been her downfall. If she had just said, "Oops, we made a mistake, we will remove the shed," it would have been a minor embarrassment. Instead, her stubbornness had led directly to scrutiny that uncovered years of criminal activity. A few months later, I was contacted by a local news reporter who was doing a follow-up story on the HOA scandal. She wanted to interview me about the shed incident that had started everything. "I appreciate the interest, but I would rather not be on TV," I told her. "What about an anonymous interview? We would not show your face or use your name." I thought about it. Maybe there was value in telling the story, helping other people understand they had rights even when dealing with HOAs. "Okay, I will do it anonymously." The interview aired the following week. The reporter did a good job of explaining how a simple property dispute had uncovered systematic fraud within the HOA. She interviewed several other homeowners who talked about the improvements since Patricia's removal. The story ended with a reminder to all homeowners to stay involved with their HOAs and not let any one person accumulate too much unchecked power. After the news story, I received several messages through the community forum from people thanking me for standing up to the HOA. One message was from a guy named Carlos who lived on the other side of the neighborhood. He said Patricia had threatened to fine him thousands of dollars for an unauthorized fence that had actually been installed by the original builder. He had been planning to pay to have it removed until he heard about my situation, which gave him the courage to fight back. Once the new board reviewed his case, they immediately dropped all fines and confirmed the fence was legitimate. Hearing stories like that made me realize the situation had been bigger than just my property. Patricia had been bullying and financially manipulating the entire community, and standing up to her on one issue had created a domino effect that freed everyone. Life continued to improve in Riverside Meadows. The HOA stopped being an adversarial presence and became what it was supposed to be, a community organization that maintained common areas and organized neighborhood events. We actually had a fun 4th of July party that year at the community pool, something that never would have happened under Patricia's reign, when every event felt mandatory and joyless. I did keep one memento from the whole experience. I had David frame the judge's order granting the preliminary injunction, and I hung it in my home office. It was a reminder that standing up for yourself, even when it is difficult and expensive, is sometimes necessary. The financial restitution from Patricia came slowly. She was making payments from prison wages, which amounted to pennies on the dollar. The HOA board eventually hired a collection agency to pursue the full amount, and they managed to place liens on some property Patricia owned. The neighborhood would eventually recover most of the stolen money, though it would take years. 2 years after the shed incident, I was talking with Sarah at a neighborhood barbecue. She was still on the HOA board and had been elected president properly by the community. "You know, we still use your case as an example in board meetings," she told me. "Whenever someone suggests we do something without proper documentation or legal review, someone always brings up the shed incident. Happy to be a cautionary tale. It is more than that. You showed everyone that homeowners have real rights and that HOAs are not all powerful. That was an important lesson for this community. Looking back on everything, I realized how easily I could have just accepted the shed and moved on with my life. It would have been the path of least resistance. I could have grumbled about it to my neighbors but ultimately done nothing, letting the HOA continue to operate with impunity. But something about seeing that shed on my property had triggered a fundamental sense of justice. This was my land that I paid for, that I paid taxes on, that I maintained. No one had the right to build on it without permission, regardless of what position of minor authority they held in a neighborhood organization. That decision to fight back had led to a judge's order, financial compensation, criminal charges against a corrupt HOA president, and ultimately a better community for everyone. It had been stressful and expensive and time-consuming, but it had been worth it. The grass that grew where the shed had been was particularly green and healthy. I had made sure to use quality seed and fertilizer when restoring that area, wanting to completely erase any evidence of the structure. Every time I looked at that spot, I felt a sense of satisfaction. Not just because I had won, but because I had stood up for what was right when it would have been easier to stay silent. Tom liked to joke that I had become a local legend. "You are the guy who took down the evil HOA president," he would say, usually after a few beers. And while that was a bit of an exaggeration, there was some truth to it. I had become a symbol in the neighborhood of the fact that individuals could stand up to institutional overreach and win. The experience changed me in subtle ways. I was more confident in advocating for myself, more willing to question authority when something seemed wrong, and more aware of my rights as a homeowner and citizen. I also became more involved in the community. attending HOA meetings regularly to make sure the new board stayed accountable and transparent. The story of the shed spread beyond just our neighborhood, too. David told me he had referred to the case in other HOA disputes he handled, and several other attorneys in the area had reached out to him for details. It turned out there were a lot of HOAs in Arizona that played fast and loose with property boundaries and homeowner rights, and my case provided a clear precedent for pushing back. 3 years after the initial incident, I was working in my backyard when I noticed Sarah walking over with someone I did not recognize. "Keith, this is Michael Chen. He is a homeowner over in the Sunset Ridge development. He is dealing with an HOA issue similar to what you went through." Michael shook my hand. "Thanks for talking with me. My HOA is claiming they have an easement through my backyard for utility access, but I cannot find any record of it in my property documents." "Did you get an independent survey?" I asked. "Not yet. That is actually what I wanted to ask about. Sarah said you used Arizona property lines and they were good. They were excellent, professional, thorough, and the documentation held up perfectly in court." I spent 20 minutes talking with Michael about my experience, offering advice on how to document everything, when to get an attorney involved, and how to handle the inevitable intimidation tactics from the HOA. It felt good to help someone else navigate a situation I had been through. After Michael left, Sarah smiled at me. "You have become the neighborhood expert on fighting HOAs. I just know what worked for me. Hopefully it helps him too." "It will. Your case gave a lot of people the roadmap for standing up to bad HOA boards." That conversation made me realize the full impact of what had happened. The shed incident had not just resolved my own problem and uncovered Patricia's crimes. It had empowered an entire community to question authority, demand accountability, and fight for their rights. That ripple effect was something I had never anticipated when I first saw that shed in my backyard. As the years went on, Riverside Meadows became known in the Gilbert area as a well-run community with a reasonable HOA. Property values increased, more families moved in, and the neighborhood had a genuine sense of community rather than the oppressive atmosphere that had existed under Patricia's leadership. I stayed in my house, happy with my property that no one could build on without permission. The backyard became my favorite place to relax, especially that far corner where the shed had been. I put a bench there, surrounded by flowers and a small rock garden. It was a peaceful spot that held a lot of meaning for me. Occasionally, I would sit on that bench and think about the whole experience. It had started with such absurdity, a shed appearing on my property overnight like some kind of bizarre magic trick. It had escalated through legal battles and court appearances, and ultimately exposed serious criminal activity. And it had ended with justice, accountability, and a better community for everyone. Tom came over one evening and found me sitting on the bench. "Still your favorite spot, huh?" "Yeah." "It reminds me that standing up for what is right matters." "That is pretty philosophical for a Tuesday evening," I laughed. "I guess so. But seriously, this whole thing taught me a lot about the importance of not backing down when you know you are right. You definitely did not back down." "Patricia probably wishes you had. She brought it on herself. All she had to do was remove the shed and apologize. Instead she lied, doubled down, and tried to bully me into submission, and ended up in prison because of it." We sat there for a while, watching the Arizona sunset paint the sky in brilliant oranges and reds. It was peaceful and beautiful, and I was grateful to be exactly where I was. The HOA scandal had one more unexpected benefit. The publicity around Patricia's arrest and conviction led to legislative action at the state level. An Arizona state representative introduced a bill requiring all HOAs to have independent financial audits and creating stronger oversight mechanisms to prevent fraud. The bill passed and became law, directly citing the Riverside Meadows case as an example of why such protections were necessary. David called me when the law passed. "Your shed made it into state legislation. How does that feel?" "Surreal. I just wanted it off my lawn." Well, now every HOA in Arizona has to follow stricter financial reporting because of what happened here. That is a real legacy. I had to admit, it felt good knowing that something positive had come from the whole mess. Other homeowners across the state would have better protections against corrupt HOA boards because Patricia had tried to build a shed on my property. Looking back now, from the perspective of years later, the whole thing seemed almost unbelievable. The arrogance it took for an HOA president to build a structure on someone's private property, and then refuse to remove it even after a judge ordered her to do so, was staggering. But that arrogance had been Patricia's defining characteristic, and it had ultimately been her downfall. The shed was long gone, but its impact remained. A community had been freed from a corrupt leader. State laws had been changed to protect homeowners, and I had learned that individual action, even against institutional power, could make a real difference. Sometimes I wondered what would have happened if I had just accepted the shed, paid whatever fines Patricia wanted to levy, and gone along with the program. Life certainly would have been less stressful in the short term. But the thought of that shed sitting on my property, a constant reminder that someone else had more power over my land than I did, was intolerable. Standing up to the HOA had been the right choice, not just for me but for everyone in Riverside Meadows and ultimately for homeowners across Arizona. It had been expensive, time-consuming and frustrating, but it had been worth every dollar and every hour. The bench in my backyard where the shed used to be became my thinking spot. Whenever I had a difficult decision to make or a problem to solve, I would sit there and reflect. There was something about that location, with all its history, that helped clarify my thoughts. Tom often joked that I should put up a plaque marking the spot where the famous shed incident occurred, but I preferred to keep it simple. The bench and garden were memorial enough, a quiet reminder of a time when I stood up for my rights and won. Years later, when new families moved into the neighborhood, they would sometimes hear the story of the shed and the corrupt HOA president who went to prison. Some people were skeptical that it really happened, thinking it must be an urban legend or an exaggeration. But those of us who lived through it knew the truth. It had been real, all of it. The shed appearing overnight on my property. Patricia's refusal to remove it. The legal battles and court appearances. The financial investigation that uncovered systematic fraud. The arrest and criminal prosecution. And finally, the new HOA board that actually served the community rather than exploiting it. Through it all, the one constant had been my determination to protect what was mine. That patch of land in the corner of my backyard was legally mine, documented mine, and no one had the right to build on it without permission. Standing up for that simple truth had changed everything. As I sat on my bench one last time, watching the sun set over my property, I felt at peace. The fight had been worth it. Justice had been served. And my backyard was exactly as it should be, mine and mine alone, free from any unauthorized structures or corrupt HOA presidents trying to claim otherwise. The grass was green, the flowers were blooming, and somewhere in an Arizona prison, Patricia Daniels was probably regretting the day she decided to build a shed on Keith Calloway's property. That seemed like justice to me.